Thank you, and good morning to everyone. I'm thrilled to be with you here this morning. Looking forward to covering off all of the biggest year in review developments from this past year in HR law. This year, like all others that we've had over the last many years, it feels like, was filled with pretty important developments for employers in Ontario to have to deal with, to manage as you continue to operate. It's not a simple time to act as an employer in Ontario, and I know how difficult it can be given the legislation that you're governed by, given all the different factors that do impact business in Ontario, and certainly as we get into a recession in the coming months, that's not going to get any easier. But I'm hopeful that here, while I go through some of these key developments, some trends to look out for, it helps you as you continue on as an employer. So with that, I am going to continue on with the presentation. I won't spend any time on this next slide. Angelica did just give me that great bio overview, so you all know who I am now. And without further ado, let's dive right in. So before I get into the agenda for the presentation here this morning, I do just want to give a bit of a roadmap. So excuse me, I'll give you the roadmap right now, then we'll get into a snapshot for kind of where things stand right now. So to start off with the agenda, with the roadmap, I want to cover 4 primary topics here this morning. So the first that I want to talk about is quiet quitting and quiet firing. I'm sure you all heard all about that over these last few months. It was a big issue in the media, a big topic of discussion, certainly for those in my industry. And I would be remiss if I wasn't kind of cover that a little bit here this morning, talk about what those are, what they mean, and make sure there's something that you are on the lookout for as employers. From there, I'm going to shift into talking about 2 new required policies for provincially regulated Ontario employers. Provincially regulated means those who are governed from an employment perspective by the Ontario government as opposed to the federal government of Canada. That includes the vast majority of employers in Ontario, and certainly the vast majority of smaller employers, which I know is going to represent most of you here. Those that are federally regulated are certain limited industries like telecommunications, interprovincial or international trucking and transportation, and limited others. But the vast majority of you, if not probably all of you here today, will be provincially regulated, and these 2 policy requirements may apply to you if you meet the eligibility criteria that we'll be talking about. From there, I want to talk about employee dismissals. This is a topic that I feel like I'm talking about year after year when I give these year in review presentations. And unfortunately, it's something that it just continues to have significant developments, continues to be something that really is important for employers to understand. Of course, that's not the first thing that we all want to talk about. It's not what we're planning to deal with as employers. However, it is something that you do have to keep in mind and take into account. And there's really important legal implications there that are involved with that. From there on, I want to finally wrap up with EDI trends and policy risks. So EDI, when I'm referring to EDI, I'm talking about equity, diversity, and inclusion. It's something that is increasingly prevalent and more and more discussed in workplaces and in society broadly. And it's something that is increasingly important for employers to understand, be sensitive to, be mindful of, and act in accordance with as you operate your organizations. And so I want to make sure we're talking about that, as it's a continued trend that is not slowing anytime soon. All right. And one thing I will mention, I do have the Q&A box open on my screen here. So if anybody has questions about the topics that we're covering as we go through, please feel free to drop those in. I haven't done many presentations since COVID that are in person, and I'll say I really do miss getting in front of a group, speaking to you all live, being able to have that interaction with the group. And I know that when there are questions, many others likely have the same questions as well. And so if you do have those questions, please feel free to drop them into the Q&A as we go. And I'll try to keep an eye out for that. And if it makes sense for me to cover that question during the presentation, I'll do so. Otherwise, I may save some questions. And certainly if you are trying to keep up with the presentation and you want to save your questions for the end, feel free to enter those in at the end of the presentation, and we will have some time for Q&A at that point. All right. So now I got ahead of myself a moment ago, but now I'm going to talk to you about that general snapshot that I said I wanted to provide. So this is just a quick snapshot of some of the big issues that are relevant to employment and labor law in Ontario right now, to HR more generally in Ontario, that I do want to make sure that we touch on. Most of these I'm not going to have time to get into in a lot more detail during the presentation. We do only have an hour, including Q&A this morning, but I want to just touch on that and make sure that they're on radar. So of course, one significant development that we've seen this year relates to the pandemic, relates to COVID-19. I'm not going to talk too much about COVID-19. I'm happy to say in this presentation, but I've got to mention it a little bit here. The province, of course, has lifted, virtually all restrictions on employers, on individuals in Ontario. Vaccine requirements that applied to certain industries have been lifted in large measure. Mask requirements have been eased. Most of them really are, have been lifted, and we are, to the extent possible, back to normal business at this point. Now, with that said, many employers did implement vaccination policies during the pandemic, requiring vaccination for all employees subject to human rights needs. That was the most common, but certainly there are different types of vaccine policies that different employers implemented. I do want to note that in many cases, those policies can still be maintained by employers. Of course, there are certain limitations to that, and certainly it's a case-by-case situation to consider. But it is something that many employers can still maintain should they choose to. Certainly, many of my clients in my practice are starting to lift those policies. They are removing the policies, and there are all sorts of implications with that. For example, those employees who may have been placed on leave, indefinite leave, once these policies are put into effect, there's a big question about, what happens to them? Do they come back to work at that point? And if so, are they entitled to some sort of compensation kind of going back during the period of the leave? In some cases, they may be, to give you a really brief answer there. And then this is a much more complicated topic I won't talk about here. And I imagine many of you may not have vaccine policies. And so I want to make sure I'm focusing on the topics that are going to be most broadly applicable to all the attendees here today. But I did want to just touch on that for you. And I do want to note that, beyond potentially maintaining these vaccine policies, there are still other, relevant considerations related to the pandemic. Of course, the numbers are back up right now, along with the RSV and the flu and the cold that are all going around right now. I'm just getting over a cold myself. And with all of those issues, I'm sure that many of you have heard about ERs struggling. There not being enough doctors to support Ontarians right now. And there are different ways that different employers, different municipalities are dealing with that. Many of you may have heard that the city of Burlington just last week reinstituted a mask mandate for city employees in virtually all sorts of scenarios, not every single one, but virtually all. And they've said that's going to be in place for the next 6 weeks. And so that's the sort of thing that some employers may do, some private employers may consider doing as well if you're struggling with outbreaks at work or what have you. Again, there can be legal implications there, but employers do have an obligation to look out for the health and safety of their workers. And as long as we've got these respiratory issues, including COVID, going around, that certainly is still a relevant consideration. There has been a pretty significant development of COVID-19 related case law in Ontario and across the country over these last couple of years. I'm sure many of you have heard the old adage, the wheels of justice turn slowly. It does take a long time for decisions to get out from the courts after matters go all the way through the court process. And so, in some cases, we're still waiting for a lot of decisions that are before the court still, that are going to provide more guidance about how courts feel about vaccine policies, how courts feel about mask mandates, etc. But we are developing more and more of a body of case law, certainly in the unionized context, arbitral context. We have a lot of arbitration decisions that have looked at the reasonableness of vaccine policies, of mask mandates, and similar types of restrictions that employers have put in place to try to protect their workforces. And that's something that continues to develop. It's something that we're continuing to keep an eye on, and certainly, we'll be writing about in our firm's blog and our firm's newsletters that we put out regularly, to make sure that employers are up to date. And I certainly encourage you to look to our newsletters and our blog for further developments there. There have been various legislative developments in Ontario this past year. The big ones were the Working for Workers Act 2021, which, as the year suggests, was in 2021, but some significant developments that came into effect this year in 2022. and then the same name act, Working for Workers Act 2022, which the government helpfully named the same, which created further developments. Those are both important for employers to have on radar. The specific issues from those two bills that I will be talking about here, again, are those required policies that are now required under the Employment Standards Act as a result of those two bills these last couple of years. I said I'm going to talk about this later, so I'll be brief right now. EDI trends, equity, diversity, and inclusion trends. Employers are being held to higher standards than they ever were before, following the various social movements of these past few years. The Me Too movement was the first significant one in society that really changed the narrative in society, and certainly for employers as well. And of course, the racial injustice movement that has been going on really throughout the pandemic and continues. Both of those issues have, among others, have really led to a significant increase in focus on EDI, greater expectations of employees, and that's why it's something that employers just really do need to be live to and considerate of as you operate your businesses. Lastly, I don't like to talk about this, I'd rather not, but we do have an impending recession, according to most economists. I'm not an economist, but this is what they're all saying. I think most are suggesting that first quarter of 2023 we should be shifting into a recession. It's an unusual one, of course. We still have an incredibly low unemployment rate, and so how this recession will impact employers is perhaps a little bit different than others, and remains to be seen. But the economists are expecting a recession very soon. Although we do have that very low unemployment rate, certainly the recession is likely to impact that in some ways. Recessions, of course, do generally lead to layoffs, lead to dismissals. And so that really can impact employers in a variety of ways. As you all feel the impact of the recession, it's something that you may have to consider. Hopefully not, of course, and hopefully you're all able to weather the storm. But to the extent that you will, that certainly will likely impact the strong job market for candidates right now. It may shift more in favor of employers, but it's also something that you need to consider, limiting your exposure to through things like termination clauses, which I'll be talking about shortly, to try to limit what your obligations may be in the event of the end of employment relationship, because as I'll talk about more, the termination entitlements in Ontario are so significant that it really can result in employers being massively impacted. And smaller employers with long service employees that may need to be let go, it truly, I don't think I'm exaggerating to say, it truly can result in employers really struggling to continue to survive. Even one termination can do that. And so it's something that it's really important that employers are alive to and are thinking about in advance, right? The worst thing to do is wait until the recession, wait until you actually have to look at the terminations before you start thinking about it. The time is now. The time is always in advance to think about how you can reduce your liability, reduce your risk as an employer. And there are really dramatic ways that you can do that quite easily and at relatively little cost. And so I'll be talking about that more in a little bit. So the next point I'm going to be getting to here is quiet quitting and quiet firing. So let's jump right in. Again, I'm sure many of you heard about this, but in case any of you are not aware of what's contemplated by the concept quiet quitting, it's a concept that really describes employees prioritizing their work-life balance to avoid burnout. This is not a new concept, of course. This has been around for a long time. There are, of course, many employees who do their job, do their work, but don't go above and beyond, don't put in tons of extra hours, etc. And that's really what's contemplated by quiet quitting. Now, this concept has really been, prevalent recently. I think it was August, September. This was in the news a lot. And the reason it's being talked about, I think there are a couple of reasons, but certainly a lot of people during the pandemic reprioritized their lives. They had started looking at other aspects of their life that they want to focus more on. And perhaps they don't want to put in as many hours or as much effort to their professional lives as they might have before. And so that certainly shifted to others, acting in accordance with this concept, quiet quitting, that perhaps didn't previously. Now, a lot of employer groups are suggesting that quiet quitting is the result of is impacting a decrease in productivity across the province, across the country, internationally, what have you. And there's certainly arguments for that, but there are a lot of other studies, a lot of other opinions on this Some say that, the decrease in productivity that truly we are seeing in a lot of different industries right now, that may be better explained by the fact that so many employees have not only reprioritized their work-life balance, but decided to go into other industries, to new industries, move to different employers. And of course, going to a new workplace and certainly going into a new industry results in a reduction in productivity. Right? There really is a bubble of an experience in some workplaces that's impacting overall productivity across the workforce, and that's certainly something that may explain the reduction in productivity. And certainly, I think many employers are still seeing an increase in productivity, especially with shifts to remote work. People still putting in longer hours than they may have before when they're not commuting to work and what have you. And there's certainly other explanations there. But it is an important concept to take into account in any event and to understand. The other point I'll just make from a legal perspective, quiet quitting, when it really means kind of doing what's required, but not doing more. It's not something that certainly would give employers, for example, cause to dismiss an employee. It can be challenging to manage as an employer, no doubt. It can certainly create a lot of operational issues for employers. But the idea that someone's just doing what's expected of them is not something that can generally be held against them as as something that results in discipline or termination for cause. So let's talk about quiet firing. I imagine perhaps fewer of you have heard of this concept than quiet quitting. It was talked about a lot once quiet quitting was really in the news a couple of months ago, but perhaps not as much as quiet quitting. And so the idea of quiet firing is really it's employer conduct that is intended to demoralize an employee. It's intended to set them up to fail, and really intended primarily to drive them to quit their job. So quiet firing being the idea that you're trying to get the employee to quit rather than having to fire them. This is not, again, a new concept. This has been around for some time. And in most cases, employment lawyers like me, we refer to the concept as constructive dismissal. So constructive dismissal is a form of wrongful dismissal that results in significant liability for employers. It really describes situations where the employer makes significant unilateral changes to an employee's terms of employment. And where that happens, the employee can respond to the constructive dismissal, to those unilateral changes, by asserting that effectively, constructively, they've been dismissed from their employment. The employer has let them go without cause, and they can treat that as having been dismissed, such that they're entitled to the termination entitlements that they would otherwise be entitled to if the employer actively let them go without cause. The law sees them effectively as the same when it comes to what the employee will be entitled to in the event of constructive dismissal. Constructive dismissal does contemplate all sorts of, again, changes to terms of employment. Often, when we talk about constructive dismissal, we talk about things like pay reductions, unilateral pay reductions, changes to hours, changes in work location, etc. But it's not limited to those types of changes. It can be less concrete, less tangible changes, such as behavior by the employer that really makes the workplace intolerable for the employee. That sort of conduct, which is more what's generally contemplated by quiet firing, that's the sort of conduct that can also amount to constructive dismissal at law. To illustrate the point, I'll talk about a decision from a couple of years ago, from 2019, out of our Court of Appeal. It's a decision called Calistro and T-Baytel. And in that case, the Court of Appeal upheld a decision where a female employee was found to have been constructively dismissed from her job. And the basis for this constructive dismissal was that she had previously been sexually harassed in the workplace by a male colleague. The employer had responded to that sexual harassment by actually letting that male employee go. However, they then sometime later rehired the male employee. And that's what resulted in the constructive dismissal of this female employee who had previously been sexually harassed by that male employee. So it wasn't new sexual harassment by that individual, but it was the bringing him back into the workplace after he'd been let go for the misconduct that amounted to the constructive dismissal. In that case, it was that single incident of mistreatment of the employee that was sufficient to amount to constructive dismissal. And certainly something like that could be a means by which an employer might try to quietly fire an employee, and it really illustrates the liability that an employer can face in those circumstances. I mentioned employees who have been constructively dismissed. They are entitled to the same termination entitlements that they would be if they were dismissed without cause in a more normal sense. They can also be entitled to much more significant damages, things like punitive damages, moral damages, bad faith damages, also discrimination damages for violating their human rights, where these types of things happen. And so it's always a very risky thing to do. And so with that, let's get to some takeaways around quiet quitting, quiet firing. The first thing that you want to ensure, this relates more to quiet firing than quiet quitting, ensure that an employee agrees to any changes that fundamentally alter the terms of their employment. Don't make those significant unilateral changes to employees' employment, and so at least certainly don't do so without fully understanding the risks that you're creating for your organization in doing that. And so if you want to make significant changes, get them to agree. Ask, offer something in exchange for them agreeing to that change, and try to have them agree. That's how you can legally make changes when they're essentially, it's not unilateral, it's no longer a constructive dismissal. But those types of changes that are made unilaterally, not only can they create the significant legal and financial risks that I've been talking about, they can, of course, massively demoralize not only the employee who's being targeted with this type of conduct, but also other employees as well. Others can see how their coworker is being treated. They may be talking to that coworker. It could really create significant demoralization across the workforce that, of course, creates many other operational, financial, and legal risks for the employer that can very easily be avoided. And how do you do that? If you do want to make significant changes to an employee's terms of employment, or if you want to end that employment relationship, be forthright about it. If you feel that you don't want that employee in the workplace any longer, the best thing to do in almost every circumstance, rather than make unilateral changes, try to quietly fire them, the best thing to do is to let them go without cause. If there's not cause, you can look at a for-cause dismissal if there's a basis for it. That's fairly rare, but it certainly does happen in some cases. But you want to let them go. That usually will be more financially beneficial. There can be kind of strategic options for the employer in letting the employee go to try to limit the overall cost of the dismissal, even though ultimately, legally, they would have the same entitlements as they would in the event of a constructive dismissal. But practically, it can result in significantly lower cost. And certainly from a morale perspective, that can be a hugely beneficial. Letting the employee go without kind of treating them differently, treating them poorly, can really help maintain the morale of the workforce and keep your other employees happy. So from there, I want to move on and talk about the new required policies for many of you here. So the policies in question, excuse me, are a disconnecting from work policy and an electronic monitoring policy. So let's start off with the disconnecting from work. A disconnecting from work policy is now required, and it has been since June 2nd of 2022, for all provincially regulated Ontario employers that have at least 25 employees. And so if you have 25 employees, or if you did as of June 2nd of this year, you do have an obligation to have a disconnecting from work policy in effect right now. Some of the questions that I often get around these policies, one is, how do you count the employees? Is it full-time employees? Is it, is it only, indefinite term employees? How does it work? The legislation is very clear. It includes all employees, full-time employees, indefinite term full-time, temporary full-time, part-time, casual employees, other sort of short-term, fixed-term employees, even if they're only there for a couple of months. If they're employed as of June 2nd, there is that obligation to have this policy. Another question I often get is, which employees does this actually have to apply to? So fine, I have the 25 employees from when you count all my different categories of employee, but who do I have to actually apply this disconnecting from work policy to? And again, the legislation is very clear on that point. All employees have to be covered by the policy. So it does have to apply to all employees, but importantly, that doesn't mean that it has to apply equally to all employees. So there can be different rules for different classes of employee. And oftentimes, there will be, for example, managerial employees may have, less of an entitlement to disconnect from work than other more frontline employees might. But certainly the policy does have to apply and address all of those different employees. I mentioned the policy was required to be implemented by June 2nd. It was then required to be rolled out and provided to all of your employees within 30 days after that. And then any new employees since then, it needs to be provided to them at the time of their hire. Going forward, if employers have 25 or more employees by March 1st of any given year, they need to roll out one of these policies. So that'll essentially apply to those employers who may not have had 25 this year, but will grow and hit 25 in future years. And any given year, when you hit 25, by March 1st of that year, you will need to implement one of these disconnecting from work policies. Now, let's talk about what these policies are really about. Disconnecting from work, the other term you may have heard these referred to as is a right to disconnect policy. And there was a ton of discussion again earlier this year around the right to disconnect, a new right to disconnect for employees, that employers now have to let them disconnect. I want to be really clear. It's called a disconnecting from work policy, not a right to disconnect policy for a reason. But even beyond that, there truly is no new entitlement, no new right for employees or any class of employee to be allowed to or permitted to disconnect from work that didn't exist before. So this policy requirement truly just requires that employers have a policy that addresses disconnecting from work. It doesn't really go beyond that. It doesn't, again, require that there would be any sort of right to disconnect granted to employees in any new way. This is really tricky, I know, for a lot of employers. I've talked to so many employers who have had their employees come to them, around June, but certainly, in the months that have followed as well, and say, hey, you can't have me work, an hour after my regular end time in my job. I have a right to disconnect now. Aren't you aware of the new rules? And so many employees do have that misconception. And frankly, it wasn't helped by the media, who were really pushing this narrative that there's a right to disconnect, and certainly wasn't helped by the government as well. The Ford government, rolled this legislation out, shortly before the election. And I don't think that they were trying to commonly correct that misconception that there was a new right to disconnect. I don't think they minded the public believing that to be the case. And for political reasons, of course. And so with that, a lot of people think there's this right to disconnect. And so, it's up to you as the employer to unfortunately be the bad guy and let your employee know, actually, no, there's not a new right to disconnect. There's a policy requirement. And in answering that, hopefully you already have a policy, or if you don't, you certainly can roll out that policy. Late is better than never, and let them know kind of what that disconnecting from work policy provides. However, a lot of employers don't want to be the bad guy. Of course, that doesn't help to retain talent, especially in the job market that we've had this last while, where so many employers are struggling to either retain or attract talent. And so a lot of employers have decided, I will grant some form of right to disconnect, even though that's not something I'm required to do as a result of this policy requirement. Now, again, if that's something that you want to consider, you want to really be careful as an employer to consider, which employees does this apply to, and really consider what the implications of that decision are. The last point I want to make before shifting over to the electronic monitoring policies is the idea that there are a lot of rules already in the Employment Standards Act, outside of this obligation to now have a disconnecting from work policy, that do in some ways provide some form of a right to disconnect. So I'll give you a couple of examples. Unless there's a regular workday that provides otherwise, or unless the employer and employee agree otherwise, employees cannot be required to work more than 8 consecutive hours in a day. Similarly, there's a cap of 48 hours per week, unless employers and employees agree otherwise. There's also a right for most employees to have 11 consecutive hours free from work each day in each 24-hour period, as well as a right to be free from work for 24 consecutive hours each week, or 48 consecutive hours every other week, depending on the workplace and what the requirements are for most employees. And so those are just some of the effectively disconnecting from work, right to disconnect rules that have been there for years and years already, and that haven't changed. So those aren't new, but there are certain entitlements for employees around hours of work and hours free from work under the ESA that do provide some sort of right to disconnect that employers need to be mindful of. All right, so let's shift now and talk about the electronic monitoring policy requirement. So I'm going to go quick for who this applies to, because it's very similar to the disconnecting from work policy. So Ontario employers that have 25 or more employees need to have an electronic monitoring policy. You count those 25 employees in the same way as I just talked about for disconnecting from work. And similarly, just like that one, the policy must apply to all employees, although different types of electronic monitoring can apply differently to different classes of employees. This one is a bit more of a recent development. It was required as of October 11th. And then again, like the disconnecting from work policy, it's required to have been provided to employees within 30 days of that date. So by about November 10th, if I'm counting correctly. Going forward, again, by March 1st of each year, if an employer gains and reaches the level of 25 employees, they're going to have an electronic monitoring policy from then on. So what are the requirements of these policies? They're a little clearer, a little more detailed than the disconnecting from work policy. So these electronic monitoring policies, they need to set out whether the employer electronically monitors its employees, how the employer electronically monitors the employees, and in what circumstances it does so. It also needs to set out the purposes for which the information may be used. So the information that's obtained through that monitoring, how might it be used by the employer? It's required to set that out as well. So that's in large measure the requirement of the policy. Certainly there are some additional, specific requirements for this policy and the disconnecting from work policy. Again, I would encourage you to go and take a look at the blogs that my firm has created about both of these to give you some more information, more detailed information on these, but that's in large measure what these are all about. So the takeaways. Let's talk about takeaways for those two policies. First of all, you want to exercise caution when you're drafting a disconnecting from work policy. What I mean by that is, and it's building on something I was talking about a moment ago, make sure that you're really considering the fact that you don't have to give any sort of a right to disconnect to your employees beyond, again, what was already there in the ESA anyway. But if you choose to give some sort of greater right, consider what you're doing. Really think about the implications of what you're offering, because the Employment Standards Act does provide that employers and employees can contract out of the minimum standards under the ESA if the employee is getting a greater entitlement than those minimums under the ESA. And essentially what that could mean is if you roll out a policy that provides for some sort of right to disconnect for some or all of your employees, that can then form a new entitlement that those employees have pursuant to the ESA, but also just pursuant to their employment contracts more generally. And that can be something that can be very difficult for you as an employer to later roll back legally and, of course, practically as well, given employee morale, the pushback that you'll likely receive, etc. Given that, for those of you who haven't already done this, it's really important. Think about what you're offering. Think about what the implications might be. Really, get your managers together to really consider, how this might impact the workplace going forward. And don't just think about, easy times. Think about that. That time at the end of the second quarter when you're particularly busy because of the work that you do, whatever the case may be. If you're, an accounting firm, think about audit season, right? Don't just think about, don't just think about the summer. Whatever the case is, think about all different times that this can apply and make sure that you're really contemplating, how you can manage this before you give this sort of right to disconnect, because again, it's hard to pull back from. So the next one here relates to the electronic monitoring policy. And again, I just want to make sure that it's very clear that there is not any new right for employees not to be monitored as a result of this policy. The policy needs to set out how and what circumstances, when, and why employees might be monitored, but it doesn't create some sort of new limitation on the right to monitor employees. In fact, in Ontario, we do have a bit of a gap in privacy legislation right now where provincially regulated employees, again, like most of your employees here, most if not all, where they don't have any statutory privacy legislation that applies to them, like some other provinces do, and like there are for federally regulated employees. And so there is a bit of a gap in the legislation there, and so employers do have fairly broad discretion to monitor their employees electronically and otherwise without violating their privacy rights. There are certain privacy rights. I don't want to go too far there, and certainly you can't do anything, but there's fairly minimal rights in Ontario in that way, and so this doesn't create any sort of new restrictions on the rights that employers already have. It just requires that employers be more transparent in doing this. In rolling out these electronic monitoring policies, keep in mind transparency is not always a bad thing. Of course, it's some employers like the idea of monitoring, not telling the employees they're doing that, and being able to catch them when they do something wrong, when they steal from the employer, or when they're whatever the case may be, not working when they say they're working, et cetera, et cetera. There's all sorts of different examples where employers might want to do that. That's generally not the best way to deal with these types of situations, where employers are going to use information they got through monitoring to discipline an employee. they need to give the employee the right to respond to that information that they have in any event. And so ultimately, you should be telling them before you let them go or dismiss that or discipline them. And if you don't do that, there could be some pretty significant, restrictions and liability for employers. And so you're gonna have to let them know anyway. Maybe let them know right off the bat. Now you have to do so. But perhaps there's other reasons to do that anyway. On top of that, it can be a huge deterrent to misconduct. If employees are aware of the monitoring that's being done, it can deter them from doing what you might otherwise be concerned that they would do, and what you're trying to monitor for. Now, of course, now that you have to let your employees know that you're monitoring them and how you're doing so, you want to consider what's the impact on morale. Are employees feeling mistrustful if you're monitoring them too much? And of course, there's lots of HR implications there that should be considered. But if you are going to do it, there could be huge value to letting them know. And again, you're required to do that now through these policies. Now, I want to be really clear as well. When we're talking about electronic monitoring, we're talking about all sorts of things. I think it's pretty clear that the requirement for this policy, came out of the pandemic, came out of the big shift to remote work across the province, but that's not all that it relates to. It really involves any form of electronic monitoring of employees. Legislation is very broad in capturing, whatever it might be. So, it might include things like keystroke monitoring, monitoring through laptop, video cameras when employees are remote. But it also could include things like monitoring their software use, whether at the office or otherwise, monitoring kind of MS Teams chats, monitoring emails, monitoring employees entering and exiting the workplace, whether that's through punch cards, whether that's through, kind of face scanners, fingerprint scanners, whatever the case may be. And so many more. There are all sorts of different types of monitoring that employers might do. And whatever it is that you do, you got to capture that in this policy. All right, so let's shift now to the next part of the presentation, employee dismissals. And so, as I said, this is something that continues to be an important thing to talk about in these year in review presentations, because it just continues to, the law continues to shift and it continues to be very important for employers. So I'm going to start off, I'm going to reiterate a big development from a couple of years ago from 2020 and talk about how the courts have built on that decision now. So I'm going to set the context first. I'm going to be pretty quick here. Hopefully I'll be able to keep you all up with me. I'm sure many of you will know some of this information already, and so I want to be quite quick. So in the event of a termination without cause, employees in Ontario have two sources of entitlements. The bare minimum entitlements that they have are pursuant to the Employment Standards Act. Under the ESA, the Employment Standards Act, they're entitled to notice of termination or termination pay, and that's roughly 1 week per year, and it caps out at 8 weeks. And then larger employers that have an annual payroll of $2.5 million or more are also required to provide severance pay to all employees who have been employed for at least 5 years or more. And that's another 1 week per year of service. And that one caps out at 26 weeks. So the total under the ESA for any employer, specifically larger employers, that's going to go all the way up to 34 weeks at the high end. Smaller employers, it's going to go up to 8 weeks. That's the full ESA entitlement. During the notice of termination or termination pay period, the up to 8 weeks, employees also have to have their benefits continued and other terms and conditions can't change to their employment. Again, that's the minimum. The second entitlement, the second source of entitlement, I should say, in a termination without cause is common law reasonable notice. So common law is what we use to refer to court-made law, judge-made law. And essentially the courts have created this parallel entitlement for employees who are let go without cause to require employers to compensate them or give them notice or pay in lieu of notice to bridge them as long as they would reasonably need to get a new job in all the relevant circumstances. And so the courts look at all these different circumstances. What's the job market? But most importantly, the employee's age. The idea being the older the employee is, the longer the notice period should be, because the longer it might take them to get another job. Their period of service, the longer they've worked for that employer that's letting them go, the more time they're going to need to get another job. And their responsibility, their role. The more senior the role, the higher the compensation, the longer the notice period will be, because the longer it's assumed it should take them to get another job. You can certainly argue, the relevance of some of those factors and how true those are, but that is the way the courts look at it and have for many decades now. The common law reasonable notice entitlement it's not calculated in weeks like the ESA entitlements are. It's calculated in months. Usually it's going to start at 2 or 3 months on the very low end. So even a very short service employee will typically be entitled to at least 2 or 3 months of common law notice at termination. And it goes all the way up to 24 months to 2 years of notice or pay in lieu of notice, during which period they're entitled to all forms of compensation, salary continuance, bonus, car allowances, benefits, et cetera, et cetera, et cetera. Whatever it is that they're entitled to as an employee, all those are form part of what they're entitled to during that common law notice period. And in some cases, extraordinary circumstances can result in longer than 24-month notice periods. Now, in some cases, there is just cause for dismissal. I mentioned before that's a very high threshold, but where the employee is, is responsible for significant enough misconduct or poor performance or whatever the reason is, they can be let go for just cause. And if there's just cause, there's no entitlement to common law reasonable notice. But there's a really important thing to understand that under the ESA, under the Employment Standards Act, there's a slightly different threshold where employees will not be entitled to the ESA termination entitlements. Under the ESA, the employee has to be guilty of willful misconduct or willful neglect of duty that's not trivial in order to be disentitled to the ESA termination entitlements. And so it's well understood at this point by the courts that the concept of just cause at common law is not the exact same as that ESA standard for willful misconduct. And there are limited circumstances where an employee may, there may be just cause to let the employee go, but the employee may not be guilty of that willful misconduct such that they're still entitled to their ESA termination entitlements, even though the common law reasonable notice obligation does not apply. Excuse me. Now, it's really important to understand that where an employee is let go without cause, the employer does have the right to contract out of the common law reasonable notice standard. They do not have the right to contract out of the ESA termination and severance pay standards, but the common law notice standard they can. And the way that that's done is through termination clauses in employment contracts. And so to give you a really extreme but not unusual example, an employee who's been there for, in a senior role for an employer for 30 years, they might be entitled to that maximum 24 months of notice at common law. But if the employer is a smaller employer, doesn't have $2.5 million or more in annual payroll, the ESA entitlement might only be 8 weeks. And so the employer and employee can enter into a termination clause, which, if enforceable, could limit the employee to the 8 weeks under the Employment Standards Act, as opposed to the 24 months that they would be entitled to at common law. And so, let's consider a, well-paid employee, couple $100,000 per year in salary. You can do the math there. You're saving more than $350,000 as an employer by just having that termination clause in the contract that's enforceable. Now, the termination clause must comply with the minimum standards of the ESA, of the Employment Standards Act. If it doesn't, the courts won't enforce them. And so there's a big body of case law for years now where Ontario's courts have found increasingly technical and somewhat unusual ways to say that termination clauses don't comply with the Employment Standards Act. In some cases, they interpret the clause to not provide for benefits to be continued as required by the ESA, or to provide that severance pay under the ESA is permitted by the employer under the clause to be paid a little bit differently than the ESA requires it to be paid. And something as small as that can result in the entire termination clause being unenforceable, because if the court says it doesn't comply with the ESA in all circumstances, the clause is no good, and then the employee is still entitled to common law notice. So now that I've set that context for everybody, I'm going to just remind, hopefully most of you are aware of this decision, remind you of this decision from 2020 called Waxdale. This is a 2020 Ontario Court of Appeal decision. And in that case, the courts held that all termination clauses in an employment contract should be read as one clause. And so if any of them violate the ESA, then they're all struck, they're all unenforceable, and the employer can't rely on them. And so the specific type of clause that was before the courts there was a very common one in a lot of employment contracts in Ontario at the time, and still very common for those employers that haven't had their contracts updated since 2020. And it's a clause that says, if there's just cause for dismissal, the employee is not entitled to notice or pay in lieu. Those were very common, but because of that slightly different ESA standard for to disentitle employees to ESA termination pay than that common law just cause standard, that clause does violate the ESA, because there can be limited circumstances where, even though there's just cause, the employee is entitled to notice or pay in lieu. And so the court in Waxdale said that clause violates the ESA, and because that deals with termination, even if it's a separate clause than the termination without cause clause in the contract, they're to be read as one clause together. And therefore, the termination without cause clause, even if that one on its face complies with the ESA, that one's struck as well. And so now, because of this other clause that isn't even relevant in the event of a termination without cause at the time of the termination, the employer can't rely on that without cause termination clause. The employee has a much greater entitlement. And so that decision from Waxdale has been followed by other courts and interpreted by other courts in a variety of different ways. And the law has shifted pretty significantly since then. Just this year, in a case called Henderson, that has really broadened how that case applies. And so in this Henderson case, the employee had a contract that had a number of different clauses. Two of them were a confidentiality clause and a conflict of interest clause. And both of those clauses said something to the effect that, if the employee breaches that confidentiality obligation under the contract or breaches that conflict of interest obligation under the contract, it will amount to just cause and the employee won't be entitled to notice or pay in lieu. And so the court in Henderson said, well, that deals with termination, even though it's not really a termination clause, it's a confidentiality or it's conflict of interest. It deals with termination, therefore it's part of the termination clause of the contract. And following Waxdale, that means that because those don't comply with the ESA for the same reason the Waxdale clause didn't that I was just describing, the termination without cause clause, even though it's completely separate than these clauses, that's not enforceable anymore either. And what this really means for employers is that you need to really take into account, when you're having your contracts reviewed by lawyers to make sure it complies with this Waxdale principle now, make sure that your termination clauses comply with the ESA. You can't be only saying, hey, look at this termination clause. You need to have that whole contract reviewed to really consider, is there something else that can be considered to, in a very broad way, to also relate to termination of employment and therefore violate the ESA and render your without cause termination clause, the one that you really want to rely on when you have to let your employees go, render that one unenforceable as well. All right, one other termination clause case or termination case that I want to talk about. It's a case called Render, and this is just really one that helps to illustrate that difference between the just cause standard at common law and the willful misconduct standard under the Employment Standards Act. So this is a case where an employee was dismissed after an investigation into allegations that he had slapped a female employee on her buttocks. In that case, the lower court held that there was just cause, the employee was entitled to nothing. The decision was appealed. And the Court of Appeal upheld the decision that there was just cause at common law. The slap on the employee's buttocks was sufficient to amount to just cause, and this employee was not entitled to common law notice. However, the Court of Appeal very interestingly said, although there's just cause here, this employee is not guilty of willful misconduct that is not trivial. And therefore, they don't meet the ESA standard to disentitle them to termination entitlements. They're still entitled to their termination entitlements under the ESA. If that sounds odd to you, I agree with you. It does seem quite like an odd decision. Slapping an employee on the buttocks, it seems pretty willful. Seems like misconduct that's not trivial to me. But the court said in the heat of the moment, this happened. In those circumstances, it doesn't rise to this level of willful misconduct under the ESA. And it just really, again, goes to show that, both of those standards need to be considered if you're looking at letting an employee go for cause to determine whether they're also not entitled to the ESA entitlements as well. All right, so the last termination case that I want to talk about is a case called Poll. And this relates to extraordinary damages. So when employers let an employee go, they owe those employees a duty of good faith and fair dealing in the manner of dismissal. So they need to treat them in good faith in letting them go. And if employers don't comply with that duty, they're going to owe the employee not only their termination entitlements under either an enforceable termination clause or under that common law standard, but also additional extraordinary damages, things like moral damages or punitive damages for how they treated the employee in bad faith. And so this is an example of a decision where $55,000 in extraordinary damages were awarded to an employee who was let go on top of 24 months pay in lieu of notice under the common law reasonable notice standard because of the manner of the dismissal. And so in this case, it was a senior managerial employee with 28 years of service. And when he was let go, he was offered a much more junior position of sales associate with much lower pay, potentially fewer hours that he turned down. In letting him go, they also walked him out of the workplace immediately, the way that I think many employers still do in really any termination to ensure they're protecting their confidential information and whatever other reasons. But they let him go and they walked him out. Under the ESA, the termination and severance pay that I was talking about, it has to be paid as a lump sum at the end of employment. In this case, the employer paid it out on a salary continuance basis instead, which is not unusual. A lot of employers get that wrong and do that. But that was a mistake that the employer made. And the employer also made another mistake, and they failed to actually issue the record of employment until quite a bit later after the termination, rather than within the week or so that's required under the federal legislation around records of employment. And those factors that I just went through, those were the basis for these additional $55,000 in damages. So walking the employee out, again, the way that many employers do in all terminations, not paying out the ESA termination entitlements as a lump sum, but paying it out on a salary continuous basis instead, making a mistake and not issuing the ROE for some time, which again, that happens. It's a mistake that happens. And offering this other lower role to the employee that would have provided them less. These are not unusual things that employers do, intentionally or by mistake, depending on which one we're talking about. And it's the kind of conduct that historically has not really been considered that serious, but it clearly shows now from this case where $55,000 of additional damages were awarded because these amounted to bad faith by the employer. It shows that the courts really are, and this is another in a long trend of these cases for the last few years, the courts are really shifting the goalposts on, what is bad faith. And lesser and lesser conduct by the employer is required to amount to bad faith damages. And so it's just even more reason that really as employers, you need to be really, really careful when you're letting your employees go in order to make sure you're treating them in good faith and not putting yourself on the hook, not only for the common law notice damages that you might owe, but also these additional bad faith damages. So really quickly to touch on some takeaways here. I know we're running very low on time, so I'll be quick. You really want to look at your termination clauses, and even if you've already had your termination clauses looked at by a lawyer before, after, since Waxdale, since 2020, you want to have them look at it again to make sure, in the wake of this Henderson decision, to really make sure that there's nothing else in that contract that might cause problems for you and render your termination clause unenforceable. I mentioned it before, and I'll just say it again now. If similarly, if you don't have a termination clause, you should get those in place. You can implement new employment contracts for existing employees. There are some, some specific things you have to do in doing that. You'll need to get legal advice in doing that, but it's worthwhile to do. And again, we're getting toward a recession. You don't know how your business is going to be impacted. The decision is now. The best time to make this decision is now. Get these contracts in place. Have the enforceable termination clauses to protect yourself. And again, potentially owe 8 weeks instead of 2 years to employees that you might have to let go, just because of business reasons. You should also ensure, again, you're conducting your dismissals with as much sensitivity as possible, and you make sure you're complying with all of your obligations. The obligations are tricky, right? Again, a lot of employers don't realize that termination and severance pay have to be paid as a lump sum rather than on a salary continuance basis. Some employers, smaller employers in particular, might not realize the record of employment obligation that they have. If they perhaps they haven't let many people go, they don't realize what their requirements are. You need to make sure that you're, being as sensitive as possible and complying with all of those rules, or else, following that poll decision, you can be on the hook for a lot. I wanted to just touch on EDI trends, policy risks. So again, equity, diversity, and inclusion is such a big issue right now in society and in workplaces in particular. I talked about it, the Me Too movement, what happened with George Floyd and the movement that's followed that. Both of these have really led to, huge social movements, huge expectations by employees of their employers. And it continues to make headlines and continues to impact the way that employees look at the workplace today. A big one in the news these last few months that I'm sure you'll all remember is the Lisa LaFlamme issue. So just a few months ago, Lisa LaFlamme was let go by Bell after she was the anchor on CTV News for many years, and the allegation was that they let her go because of sexism and ageism, and specifically they let her go because she, during the pandemic, like many women did, let her hair go gray. That incredibly led to CTV letting her go, according to the allegations. And this was, of course, I'm sure you all saw it. CTV and Bell Media more broadly were hammered in the media for this, for how discriminatory this is, for how terribly they've treated a woman who's a big part of so many Canadians' lives as the anchor on CTV News. And this backlash has been massive for Bell Media, and that's the type of backlash, perhaps not on that same scale because of how high profile CTV and Ms. LaFlamme are, but that's the type of backlash that a lot of employers can get if they're not being sensitive to their employees' rights, and certainly not being sensitive to EDI more generally. And so I just want to touch on a couple of points that, should really help you look at EDI and deal with this the right way as an employer. You really need to make sure, first of all, that when you're looking at EDI considerations, you're trying to make changes to support your employees and be respectful and mindful of EDI issues. You want to make sure that it doesn't just look like it's the flavor of the month. You need to make sure that they really, you're demonstrating that you care, that you believe in this, and that this is not just something you're doing quickly because, the media expects you to, or because a couple of employees have complained about something. It needs to be something that's real, and demonstrate how real it is to your employees by taking it seriously and really going to the lengths that are necessary to address this in the workplace properly. So some things that you want to make sure that you do. Make sure that right from the outset of the hiring process, you're taking into account equity, diversity, and inclusion issues and considerations, and all the way through to the termination of employment, the whole employment life cycle. Make sure you're taking into account all the way through. Be cautious of systemic barriers that may present by employees right from the outset of the hiring process. Consider years of service, for example, and years of experience by the employee, and consider whether years of experience in a prior workplace or in another country might be very valuable and relevant as well. Don't have kind of blinders on and looking at how much experience you need and where that experience needs to be, and having any sort of an unfair standard there to some employees. Look at the skills. Don't disadvantage employees. That's really what we're talking about there. You want to also review your policies from an EDI lens. So, revising policies has lots of legal implications, strict legal implications from a health and safety standpoint, an employment standards standpoint, a human rights standpoint, what have you, that need to be considered. But there's other things you can look at as well from an EDI lens. I'll give you a very simple example that is an important one and can have a huge impact on some employees. Incorporate inclusive language in those policies. Use gender neutral language throughout, rather than using, the typical kind of his or her that a lot of policies will use. Also, you want to look at ensuring that you address, you investigate, and you follow up on EDI related complaints. You have obligations in a variety of ways to deal with employee complaints and allegations seriously and investigate them. But that certainly doesn't stop when you look at it from an EDI lens either. Make sure that you're taking these issues seriously, that you're dealing with them fairly and respectfully and sensitively, and take these EDI issues into account. When conducting investigations, make sure you take EDI issues into account as well. Investigate from a trauma-informed lens. Make sure that you educate yourself and educate your investigators, most importantly, on these types of issues, to make sure that you are doing this the best way possible, and show again your employees that this is something that matters to you. This is something that's important for you as a workplace. So with that, I'm going to take us to the end of the presentation. I just wanted to reiterate again, please feel free to take a look at our blog on our website. We post new blogs on a weekly basis and really do our best to keep employers up to date with plain language, easy to understand updates that really do help clients. We hear so much from our clients and from others who read our blog how valuable it is. So I encourage you to take a look at that. And keep an eye out for our newsletters as well. We put out about 2 or 3 newsletters every year. And we will have one that touches on the topics that I've talked about here today and many more as our year in review newsletter coming out in just the next few weeks. And so please feel free to reach out to me, send me an email, and we can make sure that you get a copy of that when it comes out and get on our mailing list.